my fellow Americans, are we reaping our harvest of greed? Have we built our house on sinking sand? Why are we being ugly Americans?
Good morning, this is CJ Holmes, founder of Homeowners for Justice, your host today for Weekdays Live, and we have a really cool show today. I'm just super delighted because I'm telling you, we are coming up with a fix. We will fix this problem and we will stop these foreclosures and we will get justice and restitution. We just have to keep pushing. And today we've got a fabulous guest, a cool researcher, legal researcher, who's helping people understand and helping them draft these rescission and cancellation lawsuits. So I'm super excited to hear what he has to share with us today. But before we get into that, we just truly have to talk about the headline news, and that is Damone steps down. He's leaving the New York Fed as his term expires, and it's about time. They've labeled his bank as an organized criminal organization, a cartel, and here we are. If you thought the mafia was bad, try the banksters, and here they are, completely in control of everything. They're in control of our money, of the fiat credit creation, of these toxic loans. They knew it, and we know they knew it, and this is the start. We need to get these people down, and we need to then start prosecuting them step by step. Never fear, I will never ever forget about prosecution and 3 hots and a cot. Here is a petition, just in case you would like to sign that. I like the phrase, kicking corporate asses for the working classes. And trust me, as a small business owner, I really feel this way too. They have just destroyed the business owners. The retail has gone down, they broke the economy, they've ruined the property values, so whoever had real estate is screwed. Whoever bought commercial real estate has hung on long enough. There's probably going to be a huge collapse because most small business owners had some reserves. They have money that they kept using and trying to pay the mortgages and trying to stretch out and trying to hang on, and now they're run dry. So we're going to see even more disaster physically for the people, for the working classes, than what we've even seen, and that's my warning. And I'm going to talk a little bit more about that tomorrow. I'm putting up together a presentation of the housing market, what the future looks like, what kind of a bubble is going on right now, how you got to beware and watch out. But today I wanted to just pick up a few pieces and go back and review a few things and give you some more links in the comment section today of today's live stream for things that we've just talked about recently. So if you want to sign the petition, the link is going to be there. I want to remind you, this is the DocX price list. I've referred to this fairly frequently, and other people have told me they've included it in their lawsuits because basically it's the price for fraud. They forged these documents for $12.95, and it's just an outrage. And DocX, remember, she got sacrificed. Lorraine Brown, I think her name is, the founder of DocX, who merged with LPS, Lender Processing Services, and that's coming up in about 15 seconds. But I wanted to point out and remind you, this is what DocX did. She has been found guilty of fraud and has pled guilty to it, and of having all of her employees create millions of forged foreclosure documents. And that decision, actually, the settlement, was supposed to take place on March 15. So that was the hearing. We need to check up on that to see if John O'Brien at the Essex County Recorder's Office got the settlement from that hearing that they requested. They were requesting something like $1.2 million, and all of the forged documents on those properties fixed. They want the correct information, and of course they already know that the bank doesn't have it, and they were hoping that that request would break this open, this massive fraudulent scheme across the country, and really start to shift the political understanding. Remember, we just saw yesterday, Congress didn't get it. That's why they passed those laws. So now they're saying 8 years. That was 8 years later. So now it's 13 years later. And the Congress people are going, oh, we didn't really want that to happen. Give me a break. Give me a break. There ought to be a do-over. We ought to be able to go back, claw back these laws that they passed. So because of Doc Acts and lender processing services, this is why I started, on the knowns. Here is a U.S. Senator is asking Attorney General Holder, the Department of Justice, to investigate lender processing services. And so are they going to? Who knows? We already know that Eric Holder feels the banks are way too big to prosecute. But they might prosecute something like this, which is not a direct bank, and just does the fraud legwork for them. However, here's another petition. This is Lender Processing Services, of course, has speakers at the National Notary Convention. And this is a petition to say, no! Stop this. As a notary public, most everyone knows me. This was done by Ronald Gillis in Murdoch, Florida. I've filed numerous complaints regarding notaries and their fraudulent practices. Most of us know about Lorraine Brown, we just talked about that, and others at LPS. The National Notary Association has a speaker at least second year, although I caught last year's speaker list after the event, and this speaker works for LSI, a division of LPS. I find this offensive, to say the least, as I believe in integrity and law-abiding practices, and this is not a company that I would view as having any integrity or law-abiding practices. You can read the rest of the petition. I really highly recommend we all just sign it. This is an outrage, and it's a slap in the face to law and order and justice, that you have the fraudster, one of the fraudster companies of the year, speaking to the Notary Association. And we're already talking about false notarizations all over these documents. So that's why I put it up there. I wanted to briefly update you. Remember, we talked about House Bill 992. This is the Swaps Regulatory Improvement Act. I think we just talked about that yesterday. And this is an act that makes, that last 9% of the swaps legal and puts the taxpayer on the hook. And of course, remember what we said, heard yesterday was that the 800 billion of derivatives swaps mushroomed to 700 trillion in just the few years since they passed the Regulatory Financial Act in 2000, I think. And so now the banks have in front of Congress and are paying them off, pushing and paying to have all holds released. We want complete immunity, and we want somebody else to pick up the pieces after we blow up the planet. And that's really what this is. So here is where you can go to check on the status of these bills. Here is the link for the Committee on Financial Services at the federal level so that you can contact us. And here are the different chairmans and the folks involved on that committee. So let's bother them. Let's tell them this is an outrage, and we absolutely don't want them to pass HR 992. And then I did want to talk about briefly, I put this link in there, about the financial remediation framework, because this is sort of the outcome of the independent foreclosure review the last 2 years, which just blew up. No owners got anything, basically. The independent auditors got like $1 billion or some insane number being paid. They found all this fraud. Every time they found something, the bank said, oh no, that doesn't count, and changed the rules. And so here is the link that you can go and check what the payments are supposed to be. This is the remediation framework. And so, for example, I wanted to bring just a couple of things to your attention, then we'll move on. But the Service Member Civil Relief Act, and if a servicer was for service member in armed forces, they were in the military and they were foreclosed on a borrower in violation of this act, then what they would do is either suspend the foreclosure or rescind it if possible, pay $15,000, correct servicer record for any improper amounts, and correct credit reports. But if the rescission is not possible, they've already sold the house to somebody else, then it's $125,000 plus equity. So this is an interesting chart. Take a look at it. See if it applies to you or your family member or a friend or a neighbor. Pass this out so that the people can get at least something. Here's another one. Error after trial loan modification completed. So they failed, the servicer, pay attention, they failed to convert the written trial period plan to a permanent modification. Okay, now that covers like millions of people. They got sucked into the trial mod program. They paid this money in cash. Often they would go down to Western Union because that's what the servicer said they had to do. And then, you know, when their 90 days is done, oh, whoops, 90 days, boom, foreclose. And they take the house. And so, again, they would rescind the foreclosure, provide a permanent loan mod, pay $15,000, correct the servicer record. But if it's not possible to rescind, and this is for just anybody that did not get a permanent loan mod after the trial period, they need to pay attention to this, and then we need to go to the OCC and the CFPB and demand these payments. I'm not positive how you actually get that. This is the chart, but who's going to make them do it? Because the OCC already said, oh, well, the banks can just figure it out themselves. So this is truly an outrage, and we need to get our elected officials involved in that too. So again, if they did this in error, then it's $125,000 plus equity. So just a word to the wise, there's several more pages on this. You can look down, see if anything applies to you, pass it out to families and friends, hook it on your Facebook. Come on, let's make this a national movement. Let's get these people that lost their homes some restitution. That's what I say. And then I wanted to talk real quickly about the fact is that principal reduction does seem to be having some traction. This is just discussing last year, 2012, in comparison to 2011. So it's a fairly distant look back, but nevertheless, there have been some principal reductions, and some homeowners who have suffered financial hardship, they can go to the hardest hit fund. And so here is the link to that. I'm going to link all of this so you can see. This is the hardest hit fund, the program purpose and overview. So if you're in any of these states, you can see what the hardest hit, how much the funds are, and contact the people that need to be contacted. And I suspect that there is contact information on this site. I just got it today. So check it out. Let me know how that works. And if it doesn't work, then we'll try to figure out how we can make it work for everybody. Because people need to be able to go to those spots and demand, request, plead, beg, cry for this kind of help and restitution so they can keep their homes. Now, before our guest, I just really feel I must have you hear this. I've listened to it repeatedly myself. It is absolutely astonishing, and yet it's exactly what you would expect. And I'm going to preface this. This is just a few minutes, 3 or 4 minutes, in some arguments. These are oral arguments in an appeal. The woman who's in the center of the picture is for the MERS. She's for the bank, and she's talking to the justices, and they're asking her questions. And if you've been following any of our live streams and been paying attention to the tangible and intangible, to the note and the mortgage, and just remember, mortgage is deed of trust. It's basically the same. It's the security instrument, and how they've been split apart, how the mortgage, she says some fascinating things, which I'll point out afterwards too, remind you. It's contradictory. So she says one thing, and then the very next sentence says something else. And it's just amazing that she actually has somehow in her brain figured that this is appropriate. And she's been doing this kind of thing before securitization. So she really does understand some of the basics, but she's been sunk into this MERS swamp for so long. You listen, it's fascinating.
And the
few years after that,
corporate assignment of mortgage says the effective assignment date is August 2305.
Correct. The 2005 is, if you look at the plaintiff's name, it's a series 2005 trust. That trust was established in 2005, and this mortgage went into that trust on that date.
But it's in this assignment is notarized October 29, 2009, which conveniently is 23 or so days after you filed your complaint.
Correct. And if your honors understand what the purpose of MERS was when it was organized,
I think we understand.
No, I
think we understand.
But the purpose of MERS was to eliminate the need for assignments of mortgage, because prior to the securitization, actually, when I started doing foreclosure work, it was ABC Bank, and then they sold it to XYZ Bank, and then they sold it to another one. And you might have 10 assignments by the time it went into foreclosure.
An assignment, and you recorded it in the county where the mortgage existed.
Correct.
So it was easy for a title search to find out who owned
Absolutely.
the mortgage.
And that has a different function. MERS was designed for a different reason. MERS was designed to eliminate the need for all of those assignments. And the only time they really do an assignment is when it goes into foreclosure.
Was MERS the mortgagee?
Mortgagee as defined in the mortgage, yes. And they're the mortgagee and nominee for that lender, and it's assigned. So
they took the place of Fremont as the mortgagee.
As the mortgagee, right.
Okay, so how could Fremont make an assignment when they were no longer the mortgagee?
They endorsed a note. They were still the lender on the note. The lender never changed. MERS is the nominee.
Tell me, a lender and a mortgagee are two different things.
As defined in these documents, yes.
Really?
And for a different purpose.
Really?
So you have the lender on the note, and
Correct.
you have MERS on the mortgage, and that's the operational.
Right, and the purpose, and the MERS was actually set up to benefit the public, because the borrowers would get a mortgage that has a MIN number on it. And the MIN number, if you go to the MERS website, you can call or you can go in, and you will always be able to find out who is servicing your loan. And this was always a big problem before, if they didn't get the notice of servicing transfer and when the loans were assigned. So MERS served the purpose of two things. It eliminated the multiple assignments that might have happened, and it also provided a base where the borrowers could go to always find out who is servicing their loan. So the assignments, when it's a mom loan, a MERS originated mortgage like this one was, you wouldn't expect to see any assignment until it goes into foreclosure. And because the MERS rules say that if it goes into foreclosure, it has to come out. So that's the assignments of mortgage in these cases on mom loans are almost always done after the foreclosure is filed, or at least after it's referred to foreclosure.
If I get an assignment from Fremont, I'm now the mortgagee, right?
If Fremont executed an assignment of mortgage,
the note and mortgage to me, I'm the mortgagee, right?
okay, but I don't mix notes and mortgages. The notes get endorsed, but the mortgages get assigned. So when you say assign the note, I get confused because I'm not sure what you're referring to.
Let's talk about the mortgage. Fremont assigns the mortgage to me. I'm the mortgagee, right?
Okay. I'm assuming this was not a MERS originated mortgage.
Well, MERS doesn't change the basic rules of mortgage foreclosures. And MERS is not a friend of the borrower. I've seen hundreds of these, and trust me, I haven't seen one yet where MERS was a friend of the borrower. If Fremont assigns the mortgage to me, I'm the mortgagee, right?
Correct.
Fremont has no more connection to that loan, to that obligation, to that mortgage.
To the mortgage.
Right?
But you're mixing the notes and the mortgage again. And Fremont endorsed the note in blank, which makes it a bearer note. Anybody who has possession of it can enforce it. The mortgage, MERS assigned the mortgage to the plaintiff. Plaintiff actually had possession of the note. They had possession of the note before the complaint was filed. We did not include a lost note count because it wasn't lost, and we knew our client had it.
Assuming that to be the fact, as I look at the record, the document signed by the vice president, Mr. Pat, let's assume that's his name, has no date on it, right? So we don't know from looking at the
No, I agree.
whether it predates the filing. Help me out with the corporate assignment of mortgage. I'm looking at the one from MERS that's in this record. And it says, as nominee, and just above the corporate seal says, this assignment is effective. I'm not trying to be argumentative. I'm going to say it strikes me as that is a legal conclusion as distinguishing from this document was transferred on such and such a date at such and such a time, and then we make the legal conclusion that it was effective. That's my first concern. And the second was, I'll make sure I understood your earlier argument. Just above the assignment, it says, together with the notes. And you were having me follow two separate paths, note and mortgage.
Correct.
Help me out here.
Okay, the note goes with this assignment, and this entity the assignee also has possession of the original note, which contains a blank endorsement.
The note doesn't go with this because the mortgage follows
follows the note.
The note doesn't follow the mortgage.
Correct. So Wells Fargo was already in possession of the original note, and the mortgage followed it. The assignment was done for the purpose of getting it out of MERS and into the entity that filed the foreclosure action and who owned it since 2005 when it was placed into the trust. And I agree, Your Honor, that adding the assignment is effective that date. It's not a custom assignment. It's a standard document that they use, and that's the only way that the preparers could get that information onto the document. It would be nicer if it were a custom document and it said on such and such a date this deal took place and the mortgage was sold into a trust, but they don't do that.
It's doing something on summary judgment where the moving party has arguably a burden of proof because the ultimate result is to deny someone a trial. I'm just trying to make sure I understood all the documents are and what they're saying.
Okay. No, I understand, Your Honor. And again, it's their form document, and it doesn't provide for that kind of language in a different world, and they could customize everything. It might look different.
You have got to be kidding me. This is absolutely laughable. You're going to have to listen to that again, I swear, because it is just gobbledygook. It's gobbledygook. She says the notes and mortgages are separate. We do this with that and this with that. But yeah, the mortgage follows the note. The whole thing. And this is what the judges have to listen to. And this is why it's so confusing and why typically the banks are winning. Now, I want to bring Travis online here. Let's welcome him to the show. Hi, Travis. This is CJ. You were on the show.
Good morning, CJ. Nice to be here.
Thank you. And so I just played a few minutes on live stream that people could, I swear, a lot of people are going to go back and try to listen to because it's an attorney for the bank explaining to an appeals court justices about how the note does this and the mortgage does that, and the whole thing is just pretty much gobbledygook. And so the fact is, we know, probably the people watching and our viewers and contacts probably know even more about this mess and how they've used this against us to take the properties. And you've just point blank called it bank fraud in your little email to me. And I totally agree. But why don't you share with us what you found? Who are you? What are you doing? What have you found out? And what can we learn from you?
Okay, very well. If the viewers do not know my name, it's Travis Middleton. When I moved to California in 1993, I had an issue with the city of Santa Barbara about a towing of one of my vehicles. I sued them in their own court because I was angry. And as I was going through litigation, a good friend of mine said to me, "Why don't you call up Michael Brown? Because this is what he does. He specializes in criminal and civil litigation. And let him advise you on what you can do or to see what the viability of your claim is." So I did. Now, I'd been going through this probably about a year already anyway. After calling him up and talking to his clerk, he says to me, the first thing he asked me, "What court are you in?" I said, "Right in the city state court in Santa Barbara." And without missing a beat, he says, "You're going to lose. You need to dismiss this case without prejudice and get our material, learn about how to do discovery and how to vote up a pleading, how to set up your claims, and you need to be in federal district court on this case because they're going to protect their own people in their own court, in their own backyard." So I thought that was very interesting. So I followed his instructions. I dismissed the case without prejudice, and I ended up losing it anyway. So I got all his books and materials on legal research and templates on how to put together a pleading, the rules of federal district court, rules of state courts, and move a case. And that started me on the path of learning what the law really states, because you have two things going on. You have the principality of law, and how we think the Constitution allows us certain remedies. Then you have the procedural aspect of how to invoke a remedy or how to invoke your rights. And those two issues are strikingly different than you'd ever imagine. So one needs to not only understand the principle of law, but also the procedure.
Right.
They know how to go into court and stand on your rights or invoke a principle to move your case. That's what got me started in all this. 3 years ago, I had some friends of mine who had an idea of helping the homeowners in Santa Barbara against the banks. At the time, I was enrolled in some legal courses online as well. And so they wanted my help in keeping them on the right path. So I said, I'm kind of busy right now. I don't know if I have time to do it. I want to see your business plan and what your ideas are. So I met with them, and they had shown me one letter that they had drafted to challenge the bank on the note, and said this might do it, and the bank may back off. And I said, guys, I'm here to tell you that's not going to happen in reality. The bank's going to lawyer up on you and put you on the courtroom floor, and they're going to lie, steal, and cheat.
That's right. I've been saying that for years. They just lie, steal, and cheat. So how do you fight back?
So now what I was taught from Mr. Brown is, one, here's the rules of the game in the courtroom. Now I want you to remember this. The courtroom is a battlefield.
Exactly.
Law is your weapon. Opposing counsel is your enemy, and the judge is your enemy spy. They both work tandem against you to derail your case. You need to know and be very grounded in the rule of law and procedure and evidence before you walk through those doors.
Right.
Because when the judge starts playing with your legal pleading and legal claims, you need to know how to bring them back on track.
Right.
When the opposing counsel begins to lie, you need to slap them with the rules of court and the rules of evidence to show the court you understand the evidence in this case and what the lie and the fraud is. If you don't see it that way, when you get in there, you're going to be traumatized at the fact that the judge will tell you something that you don't understand, or the opposing counsel will say something that you don't not sure that it's true or accurate.
Right.
You'll get spun around and be confused. But you have to have blinders on, like a horse, and only focus on the rule of law and the evidence to support that law. That way, you won't get distracted about the lie that comes from the judge or the opposing counsel. Now, every now and then, you can find a decent judge that won't hinder you, but will allow you to do things if your paperwork is correct.
Right.
They're out there. But it seems in my investigation and my witnesses of what's going on in Santa Barbara and throughout California in these mortgage foreclosure fraud cases,
Yeah.
it is obvious to me, based on the law that I understand, the judges are biased against the homeowners, and they're actually assisting the bank lawyers in evicting you out of your property.
Exactly, and I get this kind of feedback from people in court helping others in court themselves all over the country. That this is not just California specific. This is everywhere.
So one of the things that I went through and learned a few years ago was I was in a study of our monetary system, and I was reading publications written by banks on credit and money and bank finance. I didn't know 15 years ago that it would assist me today, but I was very curious about some of the rules of banking, and I thought it was very interesting. And then one of the things that I found in publications was a case law called Daly versus Minnesota. In this case, Wells Fargo sued Jerome Daly because he missed a few payments on his property. I think it was a log cabin or something he had purchased, and he ends up in federal district court on this issue. And so Jerome Daly asked or put on the record, then what was the consideration for this contract? And the bank didn't want to answer the question. Long story short, when the judge got involved, the judge asked the bank's president, where did the source of these funds come from to fund this transaction, sir? And the bank president said, well, we kind of like created it in our books and records.
We like made it up, yes.
So wait a minute. In any contract in America, there has to be lawful consideration. So you telling me that there was no consideration in these contracts?
Exactly.
And the bank's president said, well, it was a loan, and he got the money. The court goes, well, wait a minute. If it was a contract, it has to be consideration. What species of currency was used to fund this transaction?
Exactly.
Well, at that point, the bank president had to come clean and say, well, it wasn't really money in terms of your understanding was. We just entered in our books and records that way.
Right.
Because he signed a contract.
Right.
So long story short, the judge and the jury decided that there was no consideration in this contract, and that means there was no loan.
That's right.
That means there was no contract and no obligation to the contract. So Jerome Daly won his case. So now I happen to have met the judge who oversaw that case several years ago, and he told me some things about that case that the book didn't tell me. It was very enlightening, but I didn't know then that I would need to have that information today. So I used that wisdom from the judge about this issue to tell attorneys, you have to know something about our monetary system.
Exactly.
To be able to understand what the banks have done to the consumers in these mortgage transactions.
Exactly.
If you aren't grounded in our monetary system in any respect, you're not going to know what a loan is or what a true loan transaction is. So what I do is I call it a mortgage transaction of some type. Whether it was a loan, I'm doubtful about that in the true sense of a loan. Until I see a bank's accounting records to show how they listed it on their books and records, I'm going to assume there was never a loan.
Right.
But the illusion to the homeowner, because you signed this contract purportedly, and then the deed is suggests that this loan was in the amount of X amount of hundreds of thousands of dollars.
Right.
That in and of itself doesn't make it so. That in and of itself is not proof that a loan actually occurred because they wrote it that way.
Right.
So, on that basis, I told my friends, you have to have a plan of litigation involved, because if you don't, then you're not going to go to it with your business plan to help these homeowners. So we got together, and I began to share with them some of the things I learned about the court process and by drafting pleadings around the issue of the mortgage and the deed and so forth. And I had to draw my experiences from a case in 2006. I got referred to a gentleman out of Los Angeles who the bank was suing, like the bank did in the Jerome Daly case. And I asked him, what did you file in response to this bank lawsuit? He said he filed a general answer. And I said, well, that's not going to help you. I need to get you back on track. So we ended up amending his answer to affirmative defenses and a cross complaint against the bank. And we asked for the note. With the original contract, they said that he signed, the blue ink signature.
Right.
Well, this guy had never been in court before. He was very traumatized. We went through, on this issue, 2 corporate law firms. Okay? 2 74-men law firms.
Yes.
On worth no issue.
Right.
And the judge came out to these bank lawyers and stated, after he sent a subpoena for this document, okay, guys, where is the note? The attorney said, well, we think it's in some vault in Texas. And the judge said, well, my instructions were to get it here in this courtroom. During that process, the guy that I was working with kind of lost his focus, got behind, he had a lot going on, and he couldn't keep up. He eventually lost the case, but I thought it was very interesting that we went through 2 corporate law firms.
Exactly.
Exactly. Because they couldn't produce it.
Exactly. And sometimes they just...
At that time,
yeah.
That they were securitizing these loans. But from the escrow closing papers, I picked up where they created for him.
Exactly.
I asked them, are you aware that the bank created a trust for you? And they used one of their attorney firms as a beneficiary, and they used another bank affiliate as a trustee? He goes, no, I wasn't aware of that. I said, this is what we call in Black's Law Dictionary an involuntary trust, where you had no intention of setting up a trust. So we challenged that also. I mean, these attorneys came unglued on that issue.
Yes.
So I used that to begin my work with individuals. But what led me to Recision was there was a gentleman that I had met in one of Margaret Carswell's meetings.
Yes.
And he was telling everyone that he had canceled some deeds, and there was an administrative process. I challenged him on the administrative aspect of it, and I said to him, well, banks are not government entities. They're privately owned, although they're federally regulated. As far as I know, there is no administrative process by which that you can cancel a deed with a bank. But that led me to go to the law library to try and find anything on cancellation and rescission of a deed or note. And in my second visit, I found just what I was looking for. And it's a Matthew Bender's book, and it was titled, Cancellation of Instruments. So I picked it up, and I knew what I was looking at. What I was hoping to find was a language that talks specifically about deeds and promissory notes.
Right.
On the whole, that's exactly what I found.
Good.
So I found case law on the issue. I found the requirements of what and the reasons why one could rescind the note and cancel a deed. It's all there. So with that, if you don't mind, unless you have another question, I will go into some of the statutes by which one could rescind or cancel those instruments.
Now, you keep saying the deed, and I've been writing down, I'm going to show here the law that you quoted. Let's see, just a sec. Here I've got. I keep calling it a deed of trust because the deed to me is the grant deed. It's what the person has as title to the property, and you don't want to cancel their ownership of the property, but you want to cancel the security instrument. Okay, all right. I just want to make sure that when you said deed, I'm thinking deed of trust. I've written out deed of trust, and for all those other judicial states, it would just be the mortgage, because a mortgage is the security instrument in those states where the deed of trust is a security instrument in the non-judicial states. And in the non-judicial states, the deed of trust and the foreclosure process is just a taking. They just send to the recorder's office any document they basically want to. The recorder stamps it. Once it's on record, it's presumed to be accurate, and the house is gone. And fighting back has just been a nightmare for people trying to figure out wait a minute, how do I get the idea that these documents are forged or they don't have standing or all this stuff into court to keep my house. And so people haven't been able to figure it out, and it's such a short time period, like about 4 months, that
I'm glad you brought that up about non-judicial state and what that process is like, because I want you to hold on to your sheet. That's a presumption that has been spewed out in California for as far as I know, for the last 4 years, and it's a falsehood. I'll tell you why.
Okay, good.
Now, first of all, we're not a non-judicial state. And I know courts have said that, but we're not. And the proof of that is in 2924A. California Civil Code 2924A. And I'm going to read it to you so that everyone gets this. And for over a year, I didn't see this because I was near the bottom where it talks about the transaction about sending notice of default, the right to cure and tender. I was involved in the leaves of the trees as opposed to going to the root of the problem. So a research friend of mine pointed it out to me. He goes, take a look at 24A, Travis, because I think you're missing something. So I did. And here's how it reads. 24A by its important parts A. Now, A is kind of long, so I'll read probably a few sentences from the first portion and get right to the meat of it.
Okay.
Every transfer of instant property other than in trust made only as a security for the performance of another act is deemed a mortgage, except when in case of personal property it is accompanied by actual taking possession. Now, the rest of that, the next three sentences doesn't really apply. So we'll get right to the power sale clause. Okay?
Yes.
Now, it says this is still 2924A.
Yeah.
It says a power sale is conferred upon the mortgagee, trustee, or any other person to be exercised after a breach of the obligation for which that mortgage or transfer is a security. Then it says, there's a comma there, the power, meaning the power sale, shall not be exercised except, here's the exception clause,
Exactly.
where the mortgage or transfer is made pursuant to an order, a judgment, or a decree of a court of record. I'll read it to you again. A power of sale is conferred upon the mortgagee, trustee, or any other person to be exercised after a breach of the obligation for which that mortgage or transfer is a security, comma. The power shall not be exercised except where the mortgage or transfer is made pursuant to an order, a judgment, or a decree of court of record. Now, in order to get the power of sale, you have to have an order, a judgment, or a decree of a court of record to grant you the authority to do so. What that means is the bank's attorneys have to go into court complaint against the homeowner to get that order or judgment or decree or court of record. There's other things that go on after this also that doesn't really apply, but that's where it is. Now, to further illustrate that point, Civil Code 2920 provides this. A mortgage is a contract by which specific property, including an estate for years in real property, is hypothecated for the performance of an act without the necessity of a change of possession. So, 2920A says mortgage is a contract. Now, B, I'll get back to A in a second, but B says this. For purposes of sections 2924 to 2924H inclusive, mortgage also means any security device or instrument other than a deed of trust that confers a power of sale affecting real property or estate for years on end to be exercised after breach of the obligation so secured. So, pursuant to 2920 subsection B, there is no power of sale through a deed of trust. It goes to the note because it's a contract according to 2920A. So again, for purposes of sections 2924, which is the so-called law that gives us the non-judicial procedures, a mortgage also means any security device or instrument. It says other than a deed of trust that confers power of sale affecting real property. Somehow attorneys have missed this, or they don't understand it. But it's quite clear to me, the statutes come before the procedure. So that gives light to the root of the process. And if 2924, as the courts in California have said is rule of law, they're forgetting subsection A, where it requires that they have a court order or judgment or decree from a court of record transfer to sell or sell the property.
And so basically, to summarize, because I'm always trying to net it out in words that I can understand. So basically what you're saying is that our foreclosure process, as it works right now, is violating this statute.
Yes, well, no. The attorneys are violating the statute, and attorneys who help the homeowners aren't really focused on the rule of law that kills the bank's position.
Right. I mean, they just send the recording stuff, into the recorder's office. They fabricate assignments, trustee substitutions, send them to the recorder's office. Boom, boom, boom. Count 90 days. Dump the homeowner if it's most profitable for them to do so at that time.
Oh yes, you're right. They are doing that.
Yeah.
They are doing it illegally. Okay, but and they're using those documents in court. And look at this judicial notice deed that we have that gave us power sale in the default scenario, and now we got a foreclosure sale, and title is deemed perfected. So now the homeowner needs to get out.
Right.
Now, the attorneys are focused on other issues regarding the deed of trust and the issue of default. Okay. My issue is if the loan was securitized at the onset, and we all know that they were, a mortgage only lasts. Let me put it this way. Let me back up and get into the forensics of this transaction. So when you sit down at the table with a mortgage loan officer to sign these escrow closing papers for this so-called loan, once you sign this document, you will notice that the only signature that appears is that of the homeowners. And the reason why that is, this is a process in bank known as signed in blank.
Yes.
If there was another signature, it would ruin the process for its later transfer to another entity.
Right.
So it's signed in blank so that they can transfer it or sell it to another entity. Now, if you only have one signature on this document, you don't have what's called a contract by which the lender proves that they were a party to it. What happens on the other side of it is it becomes what's called a negotiable instrument under the Uniform Commercial Code.
Exactly. It's like I just showed the MERS attorney before a judicial appeal, and she's talking over and over about how the notes are always endorsed in blank, and so those are they're like bearer bonds, and that's a fascinating point you just said.
Yeah, so like bearer bonds. Now, on the Uniform Commercial Code laws and rules, homeowners don't have a lot of remedies. In fact, under Uniform Commercial Code law, the holder in due course can enforce the obligation on the homeowner.
Right.
The problem is the holder in due course probably doesn't realize the closure is going on. And they have to come into court and show they're a real part of the action, and it would give the bank, it would give the scheme up. Because
Right.
if they come into court and say, oh yes, this was a UCC instrument and a bearer instrument, that means under Civil Code 2920, we didn't have a contract.
So if we knew how to play this tic-tac-toe, we could win if we knew how to do it.
It was either a contract for the purchase or refi of real property where everything was disclosed to the homeowner about the obligation, lawful consideration, and all parties must countersign to show they were an actual party to this agreement. That would be what it was under Civil Code 2920, and they have to show proof that they gave an actual loan. What pieces of currency did they use? Was it a check? Was it Federal Reserve notes, gold, silver, electronic draft, whatever it was? And by the way, a check doesn't indicate that it was money.
That's
a check
right.
is a promise to pay money. And the issue under our monetary system is all banks operate under the GAAP principle, meaning the generally accepted accounting principles. And on one side of the ledger, if they show a liability, it must also show a liability on the other side until it's paid. Well, what they do is, once you sign the contract, they'll take that monetary value of your home of 30 years times at least 9,
Right.
create this other security instrument valued at 9 times 30-year note, and they sell it on the market as a bearer bond. Now, the mortgage has been paid by some third-party investor. Yet the homeowner put some money into this so-called Ponzi scheme at the moment of putting money down, but they paid a few months of mortgages for 3, 4, 5, 10, 20 years
Exactly.
from their labor.
Exactly.
Can't get back. So, and the Supreme Court of the country says a man's dexterity lies in his labor. So that's his property right.
Right.
But if the bank is required to tender its assets in these transactions, okay, from its vaults. That's part of the fractional reserve banking system. So if attorneys don't understand this principle of bank tendering its assets in these transactions, or if they're fearful of raising the issue, they're going to have a hard time dealing with these lawyers in court. Because if you kill it at the root issue, I call it at ground zero, when you first signed the document.
Exactly.
Determine what it was at that point in time. Where were we at this point? Were we involved in a real mortgage transaction for the purchase or refi of real property?
Right.
Per Civil Code 2920, or were we involved in negotiating for the commercial code, by which the homeowner has no rights other than to sit back and be taken for a ride? Now, if a homeowner knew that at the onset, you would never sign the document, I promise you.
Exactly.
It all those things to you, and one of the elements of contract law in America is all elements of all obligations and conditions are required to be disclosed to everyone at the onset before signing. And if they miss one thing, you either have a breach of contract, and what I like to say was, in legal terms, it was illegality of contract. Because a breach of contract states that there was a contract that was once valid that somebody breached.
Exactly. Exactly.
I don't think there was ever a contract. It was a whole positive scheme to get the homeowner's signature so they can monetize that signature into a bearer instrument and sell it for who knows what value and get paid on the backside, while the homeowner is paying them on the front side.
Exactly. Exactly. They just get paid by everybody. Exactly.
So the remedy is rescission. And you will find in California that there's also two rescission issues. One is under TILA and RESPA. I'm not referring to those. Those are federal disclosure laws about escrow closing papers. Okay?
Right.
This is more powerful than those. These come under California law, state law. And I'm going to read some of the requirements to you. One of the things that the California Supreme Court has said is the basis for the right to cancel. Now we're referring to promissory notes and deeds of trust specifically. I didn't make this up. This is from the law books. So it reads, the basis for the right to cancel is a right to rescind the contract. The time limits for rescission apply. And it gives the court case Lieber versus Beltrami. 1959 case. Since that case, the statute of limitations for rescission action has been set for 4 years from discovery of the facts that entitle the party to rescind. That's also in the Civil Code of Procedure 337, subsection 3. So you have a 4-year window upon when you discover the facts of why you want to rescind, to rescind.
And so
Let's talk about the fact that you're out of your house. Doesn't mention the fact that you may be in default. This is about rescission of the note or the deed.
right, right. And so we find out our facts today. So that means we've got 13, 14, 15, until 2017, right?
Yeah.
Yeah.
Now, there's several bases for rescission of the note. Okay? For example, there's a reason you could do a rescission based upon, or cancellation of action based upon fraud or mistake, which are basis for rescission under Civil Code 1689B1. If the basis for of the action for cancellation is essentially one to recover real property, the 5-year statute of limitations for such actions may be applicable. See Campbell versus Ginchlet. That's a 1919 case. If the basis for relief is one for which there is no specific statute of limitations, such as illegality, which is what I always tell them to use, the 4-year statute of limitations for actions with no controlling statute may be applicable. See Moss versus Moss, a 1942 case. So now consideration would be, what did the bank tender at the onset of this transaction? Well, they said they gave you a loan. I had an attorney that wanted to play devil's advocate with me about this issue. And he said to me, I'm going to be the judge, I'm going to be the attorney making his argument about the fact that there was no consideration. I said, okay, let's do it. So he says to me, well, I say there was a loan. And if I bought my house, I got a loan, I got keys to the house. And I think what you want is a free house. And so in other words, Mr. Judge, are you telling me in your transaction that you had the home with the grant deed, granted you title and interest before you sold it to me, the homeowner? Is that what you're telling me? Or were you a conduit to facilitate the transaction and give me the illusion that you sold me a home? So if you can produce to me a grant deed that had your name attached to it prior to you giving me this loan, I might believe that argument. Otherwise, that won't go anywhere with me. There's no evidence to support that allegation. He goes, okay, then the check that came to me funded the loan. I said, is that your only story? He goes, well, the check is money. I said, well, actually, not really. A check is not money. A check is a promise to pay money. I would ask you, if you got paid by a check, since it was your transaction, did you see the check? He goes, no. Well, how do you know the one occurred? And then secondly, did the check have your name on it? Pay out to Mr. Joe Blow. He goes, well, I don't know that either. Well, if you don't know it, and from my perspective, if I didn't see the transaction, I wonder if it even occurred. So, even if you had a check attached with your name on it in this transaction by your home, they got passed to you, then it only promised the same money. Where is the source of the funding going to come from to buy this check? From your account, from the bank, or from some other place? Under the principle of GAAP, it has to come from your vault. Well, he goes, I said, well, here's what I think happened. There was an electronic wire transfer or a check made out to the title company who was holding the property in escrow at the time. The title company is not buying the home. The homeowner is. So, one, if the check isn't made out to the homeowner never got a check for this thing. The bank used the title company as a conduit to give the illusion that a transaction took place.
Right.
Secondly, if no transaction took place and the bank didn't lend its assets, then the whole deed of trust document was an illusion also. It was a slander title, and that's what it was. And it, at the least, because you didn't know you were signing a trust document, and no one signed it but you, and under trust law, everyone who's a party to a trust document was signed in their true beneficial capacity. They show proof, one, that they have power to receive or execute this document, and two, it gives somebody else reason to believe that there's some authority here. But the only thing that you receive is the homeowner. So that's a breach of fiduciary duty at the minimum, and a fraud in factum at the most.
Right.
And he said to me, wow, I never thought of it that way. You're right.
Yes.
I said, so how come attorneys aren't pleading that issue for the homeowners in both the cases? Because one, they don't understand fractional reserve banking's principles and the gap principle, or they're afraid to ask the question. And two, they're forgetting about contract law.
Right.
And when Michael Brown talks about in order to beat a bank, you have to kill them at the onset on the issue of contract law.
Right.
If there was never a contract, there was never a mortgage,
Exactly.
no obligation.
Exactly.
Which means now the issue of collecting this money is a fair debt collection violation. But that's kind of getting off point, CJ. I want to give you your views, readers. This is some more stuff about rescission and cancellation.
Right.
Our time is kind of winding down.
Oh,
So
hey, that's okay. We can take a few minutes. This is powerful stuff, Travis. Where have you been? Okay, so keep going. I've got here the specific California Civil Code of Procedure that you talked about in the other civil codes about the notice of rescission, the mistake of fact, the mistake of law, and the cancellation of the deed of trust. Can you just briefly overview that? That'd be great.
okay. All right. Now, what a homeowner should, according to the statute, is this: on the California Civil Code of Procedure, 1691, you should send out a notice of rescission to the lender about the note. Now, you can do that for a number of reasons. You can rescind based upon fraud, unlawful consideration, mistake of fact, mistake of law. So I use mistake of law, mistake of fact, and unlawful consideration because I challenged the money onto the transaction. There was never a loan. And I'll ask them what species of currency they used to fund this transaction, and did it come from the balls?
Exactly.
And of course, they don't like that, but that's the way it is.
Exactly.
So first send out notice of rescission under 1691. Now the reasons for that you'll find the 1689 California Civil Code, now not for procedures, Civil
Right.
Code
Right.
1689, subsection B and 3. Okay?
If the consideration for the
Unlawful
obligation.
consideration. Now, I didn't make that cause up. That's in the statute that way. So if the legislature of California decides they put a basis for rescission for unlawful consideration, then they must have understood about contract consideration. And if it failed in any respect, then you can rescind the note on that basis. Now, California Supreme Court has stated that once you send notice of rescission on this note, it is deemed rescinded pursuant to California Civil Code of Procedure 1691. So when you go into court under rescission and cancellation, now you're looking for what's called restitution of this rescission. And you'll be looking for the amount of monies you put into this Ponzi scheme. Put your money down, plus the monthly mortgage you paid every month for X number of years at a rate of 10% per annum. That's what the code says. So, but the issue of consideration is, of course, people don't like that issue because I think I see the writing on the wall. If you can prove the bank's consideration failed in whole or in part, there was never a loan from the word go. That means your deed will fall.
Right.
And they use this whole 2924 non-judicial foreclosure lie to the public that gives them power of sale without having to go to court and do it the right way. So rescission gives you a remedy to go in and rescind the so-called mortgage transaction for a breach of obligation or unlawful consideration, mistake of fact, mistake of law, and then go into court and have that deed canceled pursuant to either 1689 or California Civil Code 3412. So the other issue about that is there's a venue issue as well when you rescission and cancellation complaint. Now, because the statute suggests that if you are just going to cancel the note, the action becomes transitory. What that means is you can file your action anywhere in America where you're living to cancel that note. If you want to cancel the deed is local, so you have to do it where the property is situated. You could do a bifurcated action where you want to rescind the promissory note and cancel the deed. And in that instance, because the deed is being canceled, you have to have the litigation seated where the property is situated.
In that county?
in the county with the property situated. Yes. But this is all right in the law books, right down the law library. Anyone can go take a look at it for themselves. Right.
So here's a question. Let me ask you a couple of questions. I'm sure we'll be asking you back on the show again soon. A couple of the questions would be, let's take someone who, let me just summarize. This is what I think I heard. If somebody has not yet missed a payment, they could actually file these actions themselves, even if they're still making payments. Is that correct?
That's correct, yes.
And then if they got satisfactory judgment, they would stop making their payments because the note and the deed of trust would be gone.
That's correct, too.
Okay. Another thing, if a person is in foreclosure, which means they have at least a notice of default, maybe a notice of sale filed on the property. If they file, the rescission and cancellation, would that postpone any auction sales? Do you know?
Wait, ask that question again. If there was a default but no sale yet?
Yes, they're in default. So and to me that means they have, and that means throughout the nation. If they're in default, then they have a notice of default recorded on the property, or it's in the lawsuit in the quote, the way the judicial states handle. They have some foreclosure paperwork already recorded on the property. So if those owners did some action like this, would that stop the foreclosure auction?
Well, I don't know. Here's why. I'm referring to California law.
Right.
I don't know what Utah law says about rescission, or Nevada, or Oklahoma.
That's okay. What about California? What about let's just take California for now.
Okay. Under California law, from what I've been able to experience in the last couple of years, it has stopped the sale.
Right, because basically you are challenging standing. I mean, in essence, right?
Well, what's happened is you're challenging the validity of the transaction.
That's right.
One of the things I stress to people is I did a lecture a few months ago about mortgage foreclosure fraud, and when I opened up, I stated this: empty your cup of all you think you know about a loan, just for a moment, and I'm going to call it a mortgage transaction of some type. Okay? Yeah. And we're going to dissect this transaction from a contractual perspective about consideration, disclosure, and all those things. By the time I got halfway through it, people were asking me questions, taking notes, and I think I had a couple of attorneys there, and they asked me some very good questions about the deed, and I explained to them, said, well, if the deed 1-to-1, they're using probate law under trust law to create this instrument, and no one ever signs it in their true beneficial capacity. Right there, you have a breach, and it's not effective. Well, it's supposed to secure the note, he says. I said, well, you can secure a note by a number of modalities. You can secure it by saying, staple it together, or gluing it together to secure it. Or you can say that this deed secures a beneficial right and interest in the note. But there are several ways you can secure something. And it's kind of vague to me that makes the blanket statement that, the deed secures a note. Well, how? It's never revealed how it's secured. So making a blanket statement won't make it so. Just because you said it in writing doesn't make it so either.
Exactly.
The statute allows the deed to secure the note. I haven't had one attorney tell me the statute allows that yet. Not one.
They don't know. And this is part of the problem. The scheme, like you keep calling it a Ponzi scheme, it was pretty shrewd, pretty clever, and it's just sucked this whole country into it, I swear.
Yes. So, what my mentor taught me is this, and he taught me this, he reminded me of this several years ago when I was dealing with a parking issue here in town. He said, Travis, what you want to do is this. Anytime someone tells you you've got to do something pursuant to some local rule or law, your first response is, ask them to give you the page number, the statute number, and whatever, so you can go look up and verify it. And you're looking for one of two things. One, is it constitutional? Does it apply to me in my circumstance? And when I went to do that years ago, I realized there was all these so-called rules that were overly broad and misapplied everywhere, in every circumstance, and no one reads the rule.
Right.
When I begin to look at that from that perspective, now I tell people, if you tell me you have a position in law that you can do something to me, Show me the law that says so.
Exactly.
So I can go verify to see, one, if it exists, and two, if it applies to me in my circumstance. So in this case, I challenge the attorneys, you show me the statute that states where a deed secures a note in any respect. And they came up empty-handed. No one can answer the question yet for me.
Right.
And I'm still waiting to have that question answered.
Right. And I love the concept. I mean, it's just such a powerful concept where you go right to the initial heart. There wasn't any contract. So no, it nullifies everything else.
Yes.
Because you never had a contract.
Right. There was never a contract. If there was, and I said this to an attorney on the phone, I was working with a case in Los Angeles in federal district court on these issues. He called me up and said, well, what went wrong with this transaction, Mr. Milton? And I told him, well, first of all, the bank didn't tender its assets in this transaction. And
That's right.
two, it was a Ponzi scheme from the word go, and there wasn't a real loan that incurred, and they extended this person's title. That's how I see it. The bank's violated the principle of GAAP, and before it's over, I'm going to get that account ledger and find out just how they listed it, not what they listed in their defense, but how they listed it. And he goes, well, we can securitize a loan. And I said to him, I thought you might use that as a defense, but here's the problem, Mr. Attorney. When, where, and how did you disclose this to the homeowner that you were going to securitize this loan and create a negotiable instrument as opposed to a civil contract for the purchase or refi of real property? If you're telling me you had a loan, Mr. I'm going to do discovery requests and subpoenas, and I want you to produce for me on the record every species of currency you used in this transaction. He came unglued on me with that one.
Yes, because this is the heart of the matter. And I've heard others say, literally, the loan was created by the owner's signature because they just sent that paperwork to the Fed and said, create me some credit. I mean, just out of thin air.
That's right.
And
Right.
yeah, and then of course you've got them insisting that everything is endorsed in blank. So of course that makes it negotiable. They can sell it, but then exactly like you said, there is no contract. There's no contract.
I called him, and I said, well, Mr. So-and-so, I tell you what. He goes, he cut me off. He said, well, the judge's going to teach you something about law that you didn't know. And are you an attorney? I'm like, no, I'm not an attorney. But I can think for myself, and I can do legal research, and I do have some training in understanding the statutes and how they apply, when they apply, and I know how to prosecute a case. So if you're telling me you're trying to intimidate me about the judge, I'm not intimidated.
Right.
And if you've been practicing law for 30 years, maybe it's time you start getting it right.
I love it, Travis. You're so powerful. And truly, I want to say one more time that the silver lining on this crisis is being able to meet such wonderful people around the nation. They think for themselves. They're standing up. We're literally, I'm thinking, rebirthing. This is a grassroots of people that are willing to think for themselves and stand up and analyze and then help others. This is really what the nation is about, or should be about.
Right. You could take this argument in the federal court and under rescission and cancellation under state law, and still beat the banks up with it, because under the rules that I understand, in the absence of a federal regulation, state law rules.
Exactly.
And attorneys are finding out, and I've told them this a couple of years ago, if you plead securitization because you can't point to a breach of law someplace in this chain, it may not go anywhere. And the court may say, so what?
Right.
And of course, from my investigating and watching some of these cases go to the federal state court,
right,
the attorneys getting their teeth kicked in on this argument because the judges don't really want to take a look at it because you can't back it up by breach of statute. But here, you have what's called rescission and cancellation under California state law. And this supersedes the TILA and RESPA stuff.
Exactly. This is basic contract law. And in what you're explaining to me, and it makes total sense. And the fact of the matter is, this is at the very heart of it. This is where the fraud started. And so why not go right to the very ground zero and get this canceled. Now, have you had people win with this strategy?
Well, I've only had the opportunity to have this procedure put in court in the last year.
Okay.
And I've helped 1, 2, 3 individuals do this. And it's early in the stages, and I'm learning what the judge is trying to pull against the homeowner again, and trying to ignore these remedies and statutes. So 2 up on appeal, and 1 is moving through now. 2 moving through, 2 about 4 going, 2 moving through now, and 2 up on appeal. So it's interesting, the judges down in Santa Barbara were making these assertions that, oh, I'm sorry, Mr. Homeowner, but in a case like this, you have to tender the note. And since you didn't tender, your claim is invalid. Well, wait a minute. First of all, tender is usually alleged when you plead the legal claim wrongful or fraudulent foreclosure. This is not that kind of a case. And even in that kind of a case, where you plead wrongful foreclosure, the element of fraud destroys the need to tender.
Exactly.
So I see clearly the court is trying to misconstrue the pleading to get it off to the docket and hope the homeowner gives up. But what I was taught to do was you posture your case for appeals out the door. When you're in your pleading, make sure you have a statutory basis behind your claim and evidence to back up your claim. That way, if the judge goes sideways and dismisses your case, you have an appellate review issue on appeal.
Right, right. And that's only smart. I mean, that just makes total sense to me.
Yeah.
How
under state law, if the trial court is saying, well, you don't have a right to rescind because you're in default. Well, in these particular statutes, there's nowhere where the California legislature talks about being in default. It talks about rescission for fraud, mistake of fact, mistake of law, and unlawful consideration.
Right, right. When you discover these facts, and you have 4 years after the discovery.
Right.
Right. Right. And see, I have watched several little YouTube videos or streams about people making, arguments in front of the court, various courts and judges. And invariably, they, at some point in time, they tend to fall into this pattern. I call it the 1, 2, 3 pattern. 1, did you borrow the money? And 2, are you in did you stop making payments? Well, then 3, you should lose the house.
Right. They want to change the facts. I mean, the homeowner should understand, if a judge asks me that question, well, are you in default? No, I'm not in default. Because at the onset, when this transaction fact solidified and the paperwork got finished, it got sold, and they got paid 9 times the value of this note. I'm not in default. Number 2, did you stop making payments? Well, I discovered a fraud, so I want to make sure that I don't have to be a party to a fraud. No law requires that I be a party to a fraud, and the law cannot compel me to do something that is impossible. So I'm not going to be a party to fraud. So if you posture your response that way, you'll catch the court trying to trip you up. Well, are you in default? No, I'm not in default. Well, are you out of your home? That's not relevant to the issue of rescission.
Right.
Did you miss the payment? That, too, is not relevant to the issue of rescission and cancellation. The issues are, at the onset of this transaction, the bank defrauded me.
Exactly.
They can't show proof that we had a valid contract, so there was no contract. So as a matter of remedy, I am required to be made whole again. I put my consideration, my labor in the form of dollars.
Right.
This transaction. I want every dollar back.
Yeah.
Of interest.
Plus 10%. And that would be per year, right? 10% a year. Right. Right. Oh, this is really powerful stuff, Travis. I'm really pleased. One of our contacts, mutual contacts that has contacted me, knew Travis, put us in connection. I just so appreciate everybody that is helping us build this network around the country. So, Travis, we're going to have to go, but I just really thank you so much for spending the time, making it clear, helping people understand it's not over. And just real quickly, 2 more things. Owners that have lost the home, the bank has taken it back in auction. They're still in the house and they're fighting an unlawful detainer. Can this help them?
It can, but because they're behind the 8 ball and the unlawful detainer action is already ensued, they're still going to be evicted in the unlawful detainer action. They can still move this case forward and prevail in the end.
Okay, so in prevail in the end, so that would now we're talking about the millions around the nation that got booted out of their homes illegally, fraudulently, never had a contract, never really had a loan, didn't understand it.
Again, the distinction is this. I don't know if these kind of statutes are on the books in other bordering states as they are in California.
Okay, so what we need to do then, folks watching live stream, if you're in Pennsylvania, if you're in Florida, if you're in some other state, check out the links to the California Civil Code and the Code of Procedure are going to be linked on the comments. So take those and then Google. Let's find them in the other states. And if and when you find them, let me know, because I'm going to make a page, a Homeowner for Justice page. This is the code.
Do this. Inform your listeners that if they will go to the local law library and pick up a book called Matthew Bender's Forms of Pleading Practice, or look for the book from Matthew Bender called Cancellation of Instruments.
And this is Matthew Bender?
Yes.
Okay.
Cancellation of Instruments. When they find that particular book for their state, they're going to find what they're looking for.
All right. I'm going to go to Nolo Press. They often have books for California, and maybe they have them for other states. I'm not sure, but that's an online law library.
Every state has its own set of procedures that are kind of similar.
Right.
Right. I'm not sure. I'm not sure if they have identical statutes in other bordering states. I'm sure there's a similar remedy.
Right.
In other states on the state level.
But the concept.
We find out by going to the local law library and researching cancellation of instruments, either Matthew Bender or LexisNexis.
Now Travis, before you go, do these books or do these resources you're talking about, do they help people understand? Because obviously it become very important that people understand the GAAP principles, the general accounting principles that banks use. Does it go into that at all, or is there some other place that people need to go for more information on that?
Well, they can download a book called Modern Money Mechanics.
Modern Money Mechanics.
Right from the web. I got that book about 15 years ago when I was studying money and credit. It's published by the Chicago Federal Reserve Bank. It's got those about the rules of the GAAP principle and fractional reserve banking principles and what the banks can and cannot do in their monetary transactions when it comes to a loan and expanding the money supply. It's a complex read. You need to have an accountant's mindset.
Right.
To understand all of what's in it. But if you want to have it in your library of reference material, you need to get it and read the footnotes in there because it's very revealing.
Yes. Yes, and truly, it's the key to understanding. And actually, now we've segued into how do we fix this mess? And one of the ways to fix it is to reduce the private investor creation of credit, and shift that over into the creation of credit for public benefit. Because right now these banks are private institutions, and so the creation of credit benefits them in their pockets.
As a food for thought for you, in those studies I was doing years ago, I found case law that suggests that it's unlawful for banks to loan credit. So
it's unlawful to what?
It's unlawful for banks to loan credit. I've used that principle to kill credit card debt issues. And they don't want to do that in court because locally I had a case, a friend of mine was involved in a court battle involving what a credit card debt, and we put on the record a cross complaint against the bank. As one of our exhibits, we used Modern Money Mechanics. We used a guy named Walker Todd's affidavit about fractional reserve banking. Walker Todd was the attorney of 24 years for the Federal Reserve banking system. And his affidavit is very powerful in what he says about what the banks are doing with these transactions. Well, we put the bank's attorney in a little situation where they didn't want to move the case. They were afraid to come into court and talk about these issues.
Exactly.
Say they were false or somehow disingenuous. They were afraid to move the case. And pretty soon, the court, after 9 months, took it off calendar. I told my friend, if you were to take this case, because you're the defendant, and have it removed to federal district court on either RICO, And for the collection violations, they'll pay you 3 times the amount of damage they want to pay for in terms of damages. But he was kind of afraid, didn't understand the process, so the bank went away basically.
Right.
But it does work.
Oh, this is...
From what I understand from research that I've been able to discover, it is unlawful for banks to loan credit. They have to loan their assets.
Now, isn't that interesting? Yes, this definitely deserves some more exploration, and how this can be part and parcel of literally not only stopping foreclosures, but getting some restitution and justice for people that have already lost their homes.
Right.
Well, Travis, this is fabulous. I'm going to have to call a halt to it, but I'm so pleased to have made your acquaintance over the phone. And we look forward very much to successes. Please keep us posted. And I know that there's going to be people emailing me. I'm almost just wincing because I'm going to get a flood of emails about this. So I promise I will work on figuring out how people can access this kind of information, and because I also understand that an individual can only do so much. So Travis, we really look forward to a future relationship with you, and we thank you so much for sharing.
Well, thank you, CJ.
Thanks, and and keep in touch.
I will, thank you.
So that's it, guys. That's it for today. Pretty powerful stuff. And I'm really, really excited about where this is going and what we can actually expect. We'll see you next week, or next week. We'll see you tomorrow. We've got some nice attorney on tomorrow.
I was proud of me class, like my father and mother before me. They taught me to fight for my civil rights, but it's always the same old story. The rich reign supreme while the poor can but dream, and the labor all liberal or Tory. And I say, bugger the bankers and politicians, bugger the bureaucrats too, bugger the buggers who make up the rules, and if you're one of them, bugger you, and if you're one of them, bugger you.
The system is bent and the money's all spent. We're badgered from every direction.
The workers get taxed while the wealthy relax.